if I had known about this problem before I bought the property, we would have gone somewhere else. I never would have bought the property in the first place had I known that the neighbor was going to make these claims or that this problem existed. And so, what we try to do a lot in our practice is to, see what we can do to help people avoid getting in these situations in the first place. And oftentimes it's surprisingly easy to spot some of these issues before somebody closes on a parcel and winds up with some problem that can take years and just a ton of money to resolve. And so that's what this presentation is going to be geared toward, specifically what legal due diligence can people do, buyers and sellers, in real estate transactions so that they can know what they're getting into, what parcels they might want to avoid, and what issues they might want to address before they close. Why should people care? Whether you're an attorney or if you're an engineer or a surveyor, people probably ask you different questions about real estate in general, to the extent that we all work in that arena. And so hopefully the introduction there sort of set forth some reasons why people should care and what the issues are that can come up. But here I'm going to go into a little more detail about what we're talking about. So in your written materials there, I've provided sort of a working definition of what I'm talking about when I mean legal due diligence. And that's really just the process of review before the sale closes of the aspects of the property that would be material to the buyer's use and enjoyment of the parcel. And you could add to that just the ownership of the parcel, because some of the issues that we'll discuss here could go right to the core of whether someone who thinks they're buying a parcel, would have an ownership interest that stands up later on when somebody comes back and says, well, it's really my property because, that was supposed to go to me and the deed was forged, 20 years ago to your predecessor. And so then you've got potentially an expensive quiet title lawsuit where you have all this evidence and competing claims to the property. And so that goes to title. And when people hear title, they think of ownership, and obviously that's the linchpin of it. But you'll also see in the materials that there's a definition there that includes not just ownership, but also possession and custody. And for those of you who are attorneys in the audience, you likely remember from first year property class that the professor may have compared property rights to a bundle of sticks, or somebody has a bundle of sticks and each stick represents one of the rights that we think of when we talk about property rights. So that's the right to keep other people off of it, the right to convey the property, or in the legalese people say the right to alienate the property, to sell it to other people, the right to build on the property and to use the property the way that you'd like. And so all of those elements of title can be strongly affected by documents that apply to the property, many of which will be found in the public record and can be seen in a pre-closing title review. And so we'll discuss more what those documents are, how they can operate, and then how title insurance can potentially come into play to either cover or not cover specific risks to title. So you'll see there again the auditor's office is where much of this documentation will be located. Of course, there are items outside the auditor's office, such as water rights and building and zoning rules and regulations that will also have a major impact on someone's property rights, their use of the property, and in many cases those items need to be reviewed as well as the auditor's office records to make sure that somebody's not stepping into a landmine once they close. So we'll discuss more about that. I mean, you saw in my presentation on easements, we saw how many different ways an easement can keep somebody from exercising the full control over their property. And easements can be, of course, recorded or unrecorded, and that can have a major impact on what people do. Another thing that comes up all the time and that people often don't read before they close, simply because these documents can be so lengthy and so onerous to try to get through, is restrictive covenants. And so that's on page 2 of your written materials. And we see properties regularly that are in a homeowners association, and they'll have not just the original 70-page set of restrictive covenants, but then they'll have amendments 1, 2, 3, 4. There's a subdivision in Kootenai County, Idaho that at last count is on its 13th amendment to the CC&Rs. And so for somebody trying to buy a parcel, they're just faced with this mountain of paperwork to even figure out what they're getting and what they're going to be able to do. And then if they buy the property and then they are faced with all these rules and regulations down to what color they can have the mailbox, or what hours the bikes can be left in the front yard, and then the association's trying to hit them with a $1,000 fine and a lawsuit threat because of these really minor issues that nobody expected when they bought the property. There's a great extent to which issues like that can be spotted relatively quickly when somebody does that due diligence up front and goes through that process before they close. And so then we'll also get into the recorder's office or the auditor's office records, as well as some of those items like building and zoning, water rights, and septic, and ways that people can review that and potentially become insured against such issues prior to closing. So, I'll just say at the outset, and I'm going to, I think, follow up on this at the end, that a lot of what I'm going to talk about, is related to road access and water rights and septic issues, and that kind of dovetails with my first presentation. But these issues are going to come up much more frequently, in my experience, when people are buying the rural acreage. A lot of our clients, whether it's in eastern Washington or North Idaho, are the people who are buying in the county. They're not in the subdivision. They might have covenants of a road association or a water association that requires them to pay assessments at certain intervals. But these issues are coming up for the people, often coming in from out of state, wanting to get away from it all, and you really can't. Unfortunately, people try to get away from it all, and they end up closer to it all than they ever were before, because then they're interfacing with the county offices and the attorney's office and the surveyors and the engineers, and it can be a pretty burdensome situation when people have to deal with these issues after they close. And then the seller can benefit as well. I've kind of focused on issues from the buyer standpoint so far, and I think most of this presentation will focus on what the buyer can do and how they can potentially benefit from looking at these issues and taking certain steps. But the sellers, to the extent that they can learn some of this information and divulge it to the buyer, and they're sometimes reluctant to do that, of course, because they're trying to make a sale, but they can really make potentially not just the sale itself go more smoothly, but much more importantly, the post-sale process. I've written in here that probably in the last couple years, at least a quarter of my potential client consultations have been somebody coming in, about 6 months to a year after they bought a parcel of land, and they're saying that the seller failed to tell them something or other about the property. Now, often that's a condition of the house itself. Maybe the basement's flooding, and they're just sure that the seller knew about that beforehand and just didn't tell them about it because they're a bad person or whatever. But often it's issues about, say water or title issues. Maybe it turns out the boundary isn't where the seller told them it was, or I've got a lawsuit right now or some. Yes.
What about title insurance?
Well, I'll be getting into that later in the presentation. So what it can cover and what it can't cover, and and how people sometimes misconstrue what it covers and what it doesn't cover, and so that'll be I'll build into that later on. But for example, I'm working on a lawsuit right now where somebody bought property. The seller represented that there's water service to the property. Turned out that there's not, and so now we've got fraud and breach of contract claim, and that's ongoing, and that's something that's at least in this instance is expressly not covered by their title policy. I read the title policy that they had, and it expressly excludes availability of water or other resources from being something that's covered. And that's going to be pretty consistent with the law that generally applies to title insurance that we'll discuss later, that it'll typically insure only legal issues with the title. It won't unless you get a rider or some kind of extended coverage, the standard policy is typically not going to get you coverage for physical issues with the land or with the resources available from the land, such as water. And so, then they don't have the insurance coverage, but they're stuck with, potentially a very low value parcel without water. And so, now we're in a lawsuit that might take a while to resolve. And in the meantime, they don't have the insurance coverage to pay for the pursuit of the lawsuit. So it's just, unfortunately, kind of a worst case scenario that we're dealing with there. So that, that's one thing to keep in mind as we'll be talking about reasons why it's really important to review the policy and to know what's in there and what isn't there. Because again, dealing with these issues, as I talked about earlier, as Art talked about just now, can be certainly very expensive. And as I just mentioned, I think many people have an inflated view of what the standard title insurance policy covers. They'll see the list of documents, documents in the auditor's office that will be listed in the preliminary title commitment, and they'll assume that they have coverage for all of those things when the reality is that they don't. The reason those documents are listed in the preliminary title commitment is because they are not covered. They are part of the exceptions to title insurance coverage. And so I find a lot of people, even educated people who even do some work in real estate, often are thinking about transactions or going into it really with one of the foundational building blocks that they're misunderstanding. And so to the extent that we can help people understand that better and understand what the risks are, then that can go a long way toward preventing these disputes that come up and really do clients a better service, because many buyers and sellers are just not currently operating with accurate and complete knowledge of what's really going on legally with the transaction. So I put in there the old adage, penny wise, pound foolish. I mean, people are often reluctant to spend money or spend time up front reviewing the potential issues with the property because they're already putting down a lot of money for a loan and shelling out money for closing costs and moving expenses and all of that. And so it's a difficult thing sometimes to convince somebody that you could be saving a lot in the long run if you invest some time now with different professionals, be it surveyor or engineer or attorney, to take a look at some of these issues and how they might affect your property. But then a month later, or 6 months or a year later, if they're in court on a much more expensive lawsuit, you don't want to understand too late what you should have done up front. So you can save many multiples of the cost later on. And I always say, don't buy your property twice. Some people buy a property and then they get into a lawsuit about the property, and they've spent as much as it took them to buy the property in the first place. And a lot of those issues are avoidable, and that's what we're going to be discussing here. So we'll talk about I think Art's talked about and I talked about to some extent review of the documents that are in the auditor's office. But now I'm going to segue into what I was just mentioning a couple minutes ago about title insurance and what's going on with title insurance, what's the law that applies, and how do we determine when a risk is or is not going to be covered so that people can understand going in, what risk they're taking on and what risk the insurer's taking on. So you'll see that starts on page 3 of your materials, and so there are some bullet points on page 4 that go into the case law about how the Washington courts interpret insurance policies in general. And so the general rules on insurance policy interpretation are going to apply to title policies as well. In short, it's basically the same as contract interpretation. So there are some differences in that between Washington and other states, but in Washington, the courts are still going to start with the plain language of the contract, and they will look at that language and see if there's any ambiguity in the language, i.e., is it subject to two or more reasonable interpretations? If it's not, if the court does not find any ambiguity in the plain language of the policy, then it will just apply the language as written, and based on that, it will say, well, as to this risk, there's coverage. As to that risk, there's not coverage. It will reach the conclusion of the situation just based on what's on the page. But oftentimes, the court does find ambiguity in policies. That's probably less so now than it used to be, because the insurance companies now have dedicated legal staff that draft all of these policies, and they go through several levels of review. And so, for the most part, they've probably weeded out any of these points where there could be ambiguity about coverage or lack thereof. But it's still, nobody can be 100% perfect. And so there's probably going to be situations that come up where, well, we don't know what the language means. And so what does the court do when it doesn't know what the language means? If there are two or more reasonable interpretations, well, then they have to engage in what is called construction. We have to construe the language of the policy and apply legal principles and what are called canons of construction, i.e. rules that are followed in reading language that's not completely straightforward, in order to reach a solution to the dispute that's in front of them. And so the rule of construction that the Washington courts have adopted for insurance contracts, including title policies, is that, well, if the language is not clear, then we're going to read it in favor of the insured party. And so you can see that's from the Shotwell case, where there was a dispute about coverage for a right-of-way for existing roads. And I don't recall exactly where in Washington that was, but the issue was, we think the policy is ambiguous, we're going to read it in favor of the insured. And there's a reason for that. It's not just because the courts want to take the side of the little guy, although that might be the catalyst for some of it, but the true reason is because in contract law generally, there's an idea that if you draft a contract, or if you as the party have your attorney draft the contract, then the court's going to hold you responsible basically for what it says. And so if there's any language in there that's not clear, that the court has to interpret, then it's going to hold that against you. And it's going to read it in favor of the other party. And so, as I mentioned, with insurance policies and title insurance policies as well, those are almost always going to be written by the title insurance company. I've never seen an insurance policy that was written by anybody other than the insurance company. And so the court is going to read those against the insurance company in the event that it finds ambiguity. So then, in short, if the plain language of the policy covers a given title risk, or if the language is ambiguous about whether there's coverage, then the Washington court is likely going to rule that there is coverage, that the insured party can get compensation of some sort for that. And so we're going to talk more about what compensation specifically means in this context. But first, so that's how the court will determine whether there's coverage. And then there's the question, well, what is covered? When we talk about title insurance and the coverage it provides, what is within that scope and what's not within that scope. And so, as I mentioned before, and you can see on page 4 of the written materials, we're talking about legal defects in title only. So unless there's language to the contrary in the policy or in any attachment to the policy, the title insurance is only going to cover legal defects with the title rather than physical defects with the land. So the case there was from 1970. That was a situation where the buyer believed that the seller had fraudulently concealed unstable soil conditions. I think there was erosion, there was significant damage to the property, and tried to get title insurance coverage for that, and lost the case because the court held as a principle of interpretation that the title insurance policy is only covering legal title defects rather than some physical condition of the property. And then in terms of what land is covered, this seems pretty straightforward. I'm kind of surprised that there was a case on this in the first place, but it only covers land that is specifically included in the legal description on the title insurance policy. So you heard Walter Dale talk about legal descriptions and how all of that comes into play, and that really applies here in the title insurance context, because if the land is outside the legal description on the policy, yes?
I didn't want to interrupt you, but I have a comment about that with the title companies.
Sure.
The title companies have become more and more streamlined with creating their policies, and if they've insured something before, they just jump on that description and insure it again. And what's happening in my experience, probably 1 out of 15, is their description is wrong. And so just be wary. They're insuring their title insurance on that description, but if that description's wrong because they haven't done enough chain of title to determine what the description should be, then there's a battle.
And that's exactly right, because if your policy has an incorrect legal description, if your property on the ground is something else, then you're going to at the very least have a battle with them, and you might end up without coverage depending on where the title issue is located on the ground and what it is. So so 1 out of 15, that's even more than I probably would have guessed. So be aware, because only the legal description is going to be subject to coverage. And then only actual losses. So, losses that are actually incurred as opposed to theoretical losses. So when we talk about actual losses, in the context of litigation, if we're talking about actual damages, we're usually talking about out-of-pocket costs that somebody can prove they incurred as a result of someone else's conduct. And so that could certainly be what actual loss means in this context, but that's not necessarily exhaustive of what actual losses could be. If, for example, if there's a complete failure of title, i.e. somebody buys a property that they think they own and then it turns out that they don't own it because there was a fraudulent deed in the past, or there's a gap in the chain of title whereby it turns out the legal ownership is in someone else's land, and if the judge then bangs the gavel on that in a quiet title lawsuit and rules that, well, you don't own the property that you just got a deed conveyed for a few years ago, then in that scenario, the potential recoverable amount from the title policy would be the whole value of the land. So oftentimes the title policies are written so that the coverage amount will be equal to whatever it is the buyer is paying for the property, so that if there's a complete failure of title, they could be covered up to their entire purchase amount. And so then so the next one is you see about defending title issues in court. Now this is a huge one, because whether someone has a title issue or not, well, that oftentimes they don't know. They might think they have a title issue, or their neighbor might think they have a title issue if they're contesting ownership or something else, but until the judge makes a decision, you don't really know. But the problem is that to find that out requires spending a lot of time and money that many people don't necessarily have. We find that many landowners around here, whether it's in North Idaho or some in Eastern Washington, are of the land-rich, cash-poor variety. So they might own property that's assessed at a fairly high value, but they don't have the cash flow to fund a lawsuit. And so what becomes very important when people have property rights disputes is seeing, are they going to have a covered risk, and is the insurer going to pay for the defense of that risk by hiring an attorney that the insurance company works with to take on the case and represent the client's interests. So, the answer under Washington law, in short, is yes. The title insurance policy will create a duty to defend lawsuits that come up as a result of a covered title risk. And what's important to note there is that the scope of the duty to defend, the title insurance company's duty to defend a lawsuit to pay for the defense, is broader than the duty to actually pay money for, say, a failure of title or some other title risk if it turns out the judge bangs the gavel and says, no, you don't own it. The duty to defend a lawsuit arises, you can see on page 5 there, if the insurance policy conceivably covers the allegations in the complaint, whereas the duty to indemnify, i.e. to pay, is only if the policy actually covers the liability. So for the title insurance to have to pay at the end of the day for a title risk, there's going to have to be proof that the policy language actually covers the liability, but for them to have to pay for the lawsuit defense, it only has to conceivably cover it. And so that goes back to, we were talking about policy interpretation. I think it's much more likely that there could be ambiguities as to whether a given title risk is conceivably covered, because you're already in sort of a nebulous zone as is. And so if a court's looking at that and thinking about whether there's conceivable coverage, I think it's much more likely that they'll find that than that they'll find actual coverage at the end of the day. So that's where you see a lot of title companies defending suits because they have that broader duty to do so under the conceivably covers test. It's not to say that they'll automatically accept the defense of every lawsuit. Sometimes you do have to do some back and forth correspondence with them to sort of make the case that we think that paragraph 5B here covers or conceivably covers the issue, and sometimes it takes a little bit of discussion to convince them of that if you're acting on a client's behalf, but nevertheless that duty is broader. However, as you can see there, they have the ability to defend under a reservation of rights, so they have to pay for the defense still, but then if coverage is found not to exist for the title risk, then they won't have to pay. So in other words, somebody gets into a lawsuit, they make a claim on the title insurance for the defense of the suit. If the title company really doesn't believe that this is something that's covered under the policy, they can say, well, we're defending under a reservation of rights, so that even though we're defending it, we're still reserving our rights to say that we don't have to pay for this if it turns out that you lose the case and you don't own the land or what have you. And so then, at the end of the day, if they succeed on that, if the title insurer succeeds on showing coverage doesn't exist, then they wouldn't have to pay the actual losses, but they would still have to pay the legal fees. And to that end, though, because there's sort of an inherent conflict of interest in that situation, our Supreme Court, state Supreme Court, has stated that there's an enhanced obligation, duty of good faith for the title insurance company defending a property rights issue under the reservation of rights. So, they have almost a higher duty to fight for the interests of the insured because of the potential conflict that exists in that scenario. So then, just to sum that part up, title insurance can potentially offer compensation for lost value and payment for fees defending a title issue. Of course, the policy has to actually cover the title risk in question, and so there's sort of a multi-step process that we'll talk about for determining how that works and whether who's going to win if there's a dispute over whether a title risk is covered. And so we'll go into that later. And so you can see some of the bullet points there, sort of introducing the concepts we'll discuss. There are, of course, exclusions to title insurance. There are exceptions to title insurance, and not just one type of exception, but two types of exceptions. And then people can also get riders that cover specific items if they're particularly concerned about, maybe water rights issues or mineral rights issues or something of that nature, then they can potentially get a rider to their policy to provide coverage for those items. And then finally, just a brief note there that in real estate transactions, you often see the owner's policy that the buyer gets at closing, and then the lender's policy that the bank gets. And the lender's policy will typically cover more items than the owner's policy. Specifically, the lender will usually get all the standard exceptions removed so that the lender's coverage is broader than the owner's coverage. And I've seen people who didn't get title insurance because they thought the lender's policy also applied to them. And so that's certainly a mistake you don't want to make, potentially end up with nothing. But so usually we're seeing at least 2 different policies being issued at closing if there's a loan. So I mentioned title insurance exclusions beforehand in the previous slide. And so, obviously title insurance does not cover all conceivable title risks. There are some that are going to be specifically carved out or specifically blocked off from being covered in the first place. And, the reality is that if an item's not covered by title insurance, then there may be no legal recourse for the property owner to resolve the issue because maybe they can't afford to then pursue litigation over it. And so they've got to try to either live with the issue or reach a deal with their neighbor. And depending on the neighbor's circumstances, they might be really taken advantage of in that because, somebody else comes up from California with a bunch of money. They're going to kind of be in the driver's seat if they know that the neighbor to the east isn't going to be able to pay. So getting into that in more detail, here we have title insurance exclusions. And so exclusions can be defined as things that are outside the scope of title insurance entirely. And it can be somewhat difficult. I've read many different resources on how to define exclusions versus exceptions. And there's a lot out there that's pretty fuzzy. Some resources that I've seen will treat exclusions and exceptions as interchangeable. I don't know if there are any title industry folks in here who might be able to opine on how they approach it, but my understanding, upon reading title policies and reading some of these cases is that exclusions are the boilerplate language that will be typically the same on each policy and will simply say that certain things are outside title insurance coverage, period. So, on page 6 of the written materials, you can see there's sort of to the extent I'm able to create visual aids on the computer, there's something there and some concentric circles going around. And so the smallest one in the middle can be thought of as the covered risks, what's included under the covered risks section of a title policy. Then you have the standard exceptions circle, the special exceptions circle, and then the exclusions can be, I guess, thought of as sort of the white space around all of that, because those are things that just are outside the whole circle and just are really out of the conversation of things that we talk about when we say what's potentially coverable in title insurance. And so the exclusions, I don't have with me, I didn't want to create too much paperwork for you guys, but there is the standard ALTA owner's policy, American Land Title Association policy that's been in force since 2006. And that's what a lot of title policies that you see are based on, is that 2006 template ALTA policy. And so the exclusions are usually on page 3 of that. And some of what is included there would be building and zoning issues, for example. They're not going to even think about covering those. Rights of eminent domain, and then risks that the insured knew about going into the transaction, or which result in no loss. So that kind of makes sense, because as we'll discuss later, when somebody buys property and they know about a certain title risk going into closing, they're going to be pretty much stuck with that because otherwise they should have backed out. So you can see building and zoning issues are going to be excluded because if not, then the title company would have to undertake research on every parcel about what jurisdiction is it in, city, county, what city code or county code provisions apply, and it would just be a really impractical undertaking for them to try to figure that out for every parcel. It would drive premiums for title insurance probably through the roof. And so just from a practical business perspective, there are certain things that simply have to be in the exclusions. And so, for example, building and zoning is going to be one of those. Now, something else that you sometimes see in the exclusions, which surprises some people, even surprises me to an extent, is you'll often see easements that are not shown in the public records. In other words, if somebody buys a property and it turns out that the neighbor is claiming a prescriptive easement or an implied easement or something else for which there's no document at the auditor's office and for which there's been no court judgment recorded at the auditor's office, then that will often be in the exclusions to title insurance coverage, because again, for the title company to try to cover that would require really prohibitive work beforehand to try to figure out, well, for each of these 50-acre rural parcels, are any of the neighbors claiming prescriptive easements for it based on use that took place decades ago? And that's just not a pragmatic thing for them to have to do. So those unrecorded easements will often be left out of title insurance coverage entirely, which again, people think, well, isn't that what title insurance is for? But there are reasons why it's not. I mean, I get why people think it should be covered, and sometimes, there might be policy riders that people can get to bring those into coverage, but oftentimes they'll just be in the exclusions, because otherwise there's just no way to figure out what parcels might be at more risk than others. So again, I said the exclusions are like the white space around those circles on page 6, and so they're just outside the scope of the covered risks entirely. But then the question becomes, well, given that we have these exclusions and these covered risks, how does somebody with a title insurance policy go about trying to argue with the insurance company about whether a certain title risk is or isn't covered? So that's the next slide here. And there's a burden shifting approach under Washington law, and this is similar for Idaho law as well. The first thing that has to happen for an insured to make a legal argument that they're entitled to title coverage for a certain risk is they have to make a showing on the face of it, or see the legalese there, prima facie. So basically just on the surface that the covered risks language in the title policy provides coverage for a given risk. If they cannot make that showing to the court's satisfaction that the plain language of the policy or the ambiguous language read in favor of the insured provides coverage for the situation, then the court's just going to strike it down. It's going to say, well, then there's no coverage. You couldn't even meet your first step obligation to show me where in the document the language provides coverage. So in that situation, the case will be dismissed and the insurer will probably win on summary judgment. On the other hand, if the insured can make a showing, at least on the face of it, that the covered risks language in the policy gives them coverage for whatever they're trying to obtain coverage for, well, then the court, it doesn't end. The court then gives the insurer the chance to come back and to make a showing that, well, even if this is at least, superficially, perhaps under the covered risks language, we're still going to argue that it's within this exclusion or that exception to coverage, so that even if it looks like it might be in covered risks, we've nevertheless elsewhere in the policy taken it out of coverage. And if the insurer can successfully point to language in the policy exceptions or exclusions that takes the risk out of coverage, then the court is going to likely rule that no coverage exists. And so, again, the burden starts with the insured party, and then it shifts to the insurer. And all the while, there's the application of the rule that if there's an ambiguity in the language, again, the insurance company is likely going to have to pay for that. And so that's so we've talked about exclusions. We've talked about how the burden shifting approach works to policy interpretation and how that's applied. And so now we're going to start talking about, again, title insurance exceptions and how I distinguish that from exclusions is that I think of exceptions as being carve-outs from the covered risks. In other words, I think that for the most part, these are things that could arguably be under covered risks, but which the title policy language, the drafters, being the insurance company, have chosen for one reason or another to take out of coverage. And so I mentioned that there two different types of exceptions to title insurance, and those are the standard and the special exceptions. And so you'll see there's the phrase regional exceptions. And that's another way of referring to the standard exceptions. And the reason for that is because the standard exceptions in a given title policy are usually going to be based on what region the property is in. So, for the properties that I work with here in the West, the standard exceptions are usually going to include water rights, mineral rights, mining claims, often prescriptive easements. If they're not in the exclusions, prescriptive easements might be in the standard exceptions, and other issues that come up for our region. If you're dealing with a property in, say, Florida, the standard exceptions for title over there probably aren't going to refer to mining. There might be, hurricane issues or other natural disaster related issues that might be accepted from title coverage there. But the bottom line is that the standard exceptions are going to be based on regional issues that have come up time and again, so that the title insurer is saying, well, we just can't cover these. It's too burdensome. And so let's see. There I go. And so you'll see on page 8 there. I've got some more examples of the Western regional exceptions from the standard Alta title policy and how that works. So standard exceptions can typically be removed if somebody pays for extended coverage. So I mentioned that the lender's title insurance policies at closing of a real estate transaction will usually get the standard exceptions removed, and so that means the lender will typically be covered for these issues like taxes or assessment issues that haven't already been recorded as liens, or water right issues, or and here's an interesting one here. Any encroachment, encumbrance, violation, variation, or adverse circumstance affecting the title that would be disclosed by an accurate and complete land survey. So somebody buys a property and it turns out the neighbor's house is encroaching on their land by 15 feet. This is an actual case I had last year. I was representing the person who bought the house and who was then told, well, your house is encroaching by 15 feet onto my property. And somehow the city in question had issued a certificate of occupancy, and somehow this had all been done and inspected, and this was approved, and I'm still not exactly sure how that happened given setback rules, but nevertheless that occurred. And so I'm always thinking, well, is there a potential for a title claim here given the issue we're dealing with? So I got the title policy on my client's property, and I saw that exception right there, which hadn't been removed, and so again, that encroachment of the house is something that would be disclosed by an accurate and complete land survey, so it's going to be out. So even if you're getting title coverage, you still really behooves any buyer to make sure that there's a survey done if there hasn't been one done before, and to understand if there are any encroachments. Because those encroachment lawsuits can be, very expensive, and unless you get the standard exception removed for that, you're going to be paying for that out of pocket, and you're not going to be having a very good time. Water rights issues, as mentioned, and we know, obviously there's been an adjudication going on here in Washington State for 40 years plus. In Idaho, we've got adjudications of water rights going on, and we get clients pretty frequently who are saying that, well, this is what the State Department of Water Resources says my water right is versus, here's what I think, and I think they're shortchanging me on quantity, and, they're saying that my priority date for my water right is, 30 years, sooner than it actually is, and so, what can you do? I need to go after them and get my record corrected so that I can actually use the water the way I thought I was, and again, that's going to be something that falls outside of title insurance coverage unless someone gets that standard exception removed. Taxes and assessments, that could be your irrigation district, obviously the county property taxes, if they haven't already recorded a lien, then that's not going to be covered, and that could be really risky because, obviously we know if you don't pay the property taxes for a certain period of time, then the county can seize the property and sell it on the courthouse steps. So again, there's every reason to be checking into that stuff beforehand, and it's pretty easy to do. And then here's just finally on this, I'm looking at page 8, any facts, rights, interest, or claims not shown by public records, but which could be ascertained by an inspection of the property or by making inquiry of persons in possession thereof. So a lot of that's going to be easements. I'll mention this case later, but did an easement case where someone had an easement in their deed. They didn't know you have to record deeds, so they had the deed just in the drawer somewhere for almost 40 years. In the meantime, their neighbor bought the property next door. The easement hadn't been recorded, and so he said, well, you can't enforce your easement against me because it wasn't recorded. And then the issue in that case came down to whether that neighbor nevertheless could have found out about the easement claim by doing a fuller inspection of the property or by contacting the people claiming the easement to see, well, it looks like there's a road here. Are you using this road? How often do you use this road? Are you claiming some kind of easement right to do so? And for those issues, that's going to be under standard exceptions. And you can see it's kind of inherently vague in a sense, or nebulous, because who's to say what would have been ascertained by an inspection or inquiry? How detailed does the inspection have to be? How much inquiry do you have to do? And those are all issues that kind of have to be decided on a case-by-case basis, looking at the facts and circumstances. But at the end of the day, it all argues for doing more inspection rather than less, especially if you're not getting these standard exceptions removed. So you can see the rest of those there. I think some of them are pretty self-explanatory. And like the exclusions, those are going to often be boilerplate language in the title policy. It could vary region by region. But for parcels within the given region, they're typically going to be the same. And so those are the standard exceptions. And now, as I mentioned, there are special exceptions to title insurance coverage. And so that language starts on page 8. And so again, that's what's called Schedule B2 in the standard Alta owner's title policy. So sometimes you'll hear people use the phrase Schedule B2 exceptions, and that's what that's referring to. It's because it's in the section of the policy that's headed Schedule B2. And so for the most part, these special exceptions are going to be comprised of documents that have been filed at the county recorder's office or the county auditor's office. And these aren't boilerplate. They are specific parcel by parcel exceptions depending on what's in the public record for a given parcel. So, this could be any number of things. This could be recorded liens, recorded judgments, recorded easements, recorded restrictive covenants for a subdivision, recorded boundary line adjustments, records of survey, plats. All of these documents and more that get filed at the county auditor's office are, if the title company is on the ball, they're going to include them in the special exceptions. Now, sometimes they don't. Sometimes they forget to put something into special exceptions, and we'll discuss the potential recourse or lack thereof in those situations. But those special exceptions to title coverage will be in Schedule B2 of the policy. And then, sometimes you'll see other items there too, like property taxes will often be included in special exceptions. So the title company will research with the county and figure out, well, property taxes appear to be up to date, but there's another payment coming due in a few months, and so we're putting that in the special exceptions because we're not going to pay if somebody, turns out somebody was off on the property taxes. But as mentioned before too, it's incredibly important to know that these issues, these public record issues, are not covered. As I mentioned before, I've heard a number of people when I talk about recorded easements or their HOA, CC&Rs, well, isn't that covered by title insurance? I mean, they list it in the policy. Well, again, they're listing it there because there's not coverage for it, so that if it turns out you buy the property and there's an issue with the neighbor's recorded easement or an issue disclosed by a recorded survey or some other document filed for public record, then you're just going to be out of luck. The title company is not going to fund your defense of the issue, and then even if it costs you money at the end of the day, you're not going to be compensated for that. So one way that people can, typically pretty quick way that people can really mitigate that potential is just by reviewing those, or having professional counsel review those documents and just figure out what they are and what they mean and how they affect the use and ownership of the property. And for most parcels, especially if it's a parcel that's within a subdivision, these aren't going to be super extensive, but so it can be really a pretty small investment of time and money that nevertheless can disclose things that potentially could be a big deal. Something people always want to know about, I think I mentioned this in my first presentation, is road access, and specifically if there's a private road, is there a recorded easement? I've had a number of people who ask me to review parcels that they're considering buying for the express purpose of telling them if there's a legally enforceable access, because they go in understanding that it's not on a public road. And so maybe the seller or the realtor or somebody has told them, well, sure, I think that there's an easement over this road or that road, but it's not on a public road. And so they've engaged me in those situations to review the public title record for the parcel and then render an opinion for them about whether there is legally enforceable access based on the public record. And there are times that I've told them there's not. I reviewed a parcel in Washington about a year ago, and the purported easement that was being promoted to the prospective buyer as being the legal access, well, it turned out to be an easement that a developer had granted to himself. So I mentioned in the prior presentation that easements that you grant to yourself are not valid. So even if somebody writes a document, it says, I hereby grant easements over all these parcels that I own, they go file that at the county auditor's office, well, it's not going to be enforceable. And I told the client that, and then they brought it up with the title company, and the title company lawyer said, well, yeah, that's right. And they ended up not closing on it and probably saving a huge headache down the road. Another issue was somebody wanted to know about the drain field. They were buying a property near one of the lakes around here, and they had reason to know going in that there was a potential issue about whether there was an enforceable drain field easement for them to have the septic equipment going out there. And again, I reviewed it, and based on my reading of the deed, was that the drain field easement in question was an easement in gross. It was not an easement appurtenant, which, if you recall from earlier today, is an easement that runs with the land. The language of it was such that the drain field easement would only apply to the specific grantee listed on that document, and not to anybody else down the road. And so, then I told the guy, well, this is my opinion. I don't think you're going to have an enforceable drain field if you buy this property. And we tried to discuss with the the owner of the neighboring property and the different realtors if there was a way to resolve the situation. Unfortunately there wasn't. So he walked away from the sale, which was too bad. But at the same time, he potentially saved a lot of time and money if somebody later on was going to come in and try to deny him the use of that drain field. So when you look at these special exceptions documents and you see what's in the public record, although these issues aren't disclosed by title insurance, it can be sometimes fairly simple to avoid potentially huge problems down the road. And so we talked about the scope, that they're parcel specific and not boilerplate. And so they're important too when we talk about these recorded documents, because they create what's called constructive notice. So Art, when he was speaking earlier, he defined constructive notice, I believe, to the effect of everybody in this room, everybody in the world. is legally charged with knowledge of whatever documents have been filed at the county auditor's office. And so that's kind of a maybe counterintuitive concept because, well, if I haven't personally seen it or read it, then how is that fair? I mean, maybe somebody told me differently. Maybe the seller represented to me that no one has an easement over this property, and then I buy it and it turns out that the neighbor comes down, barreling down the road at 50 miles an hour, and then shows me their easement document when I try to call them on it. But it's not going to matter because you've got again constructive notice of everything there, and the reason that's so important is because again you're not going to have legal recourse virtually every time somebody tries to spike some document that's in the public record and say you can't apply this to me for one reason or another. They're going to lose that case because even if you had no idea, then the court's still going to say, well, it was in the auditor's office. You knew about it. You knew about it even if you didn't know about it. That's basically how you might define that, and so that's and so we'll get into later. Well, what happens if the title company leaves out a document from its title report? And there are situations where that happens, and then people try to move against the title companies, and that can be pretty interesting. But and then that's why we see or often see, not always, sometimes people will buy obviously without contingencies, but frequently you see purchase and sale agreements with maybe a 5 to 10 day period, the title contingency period, where somebody can get the preliminary title commitment where the title company says, well, here are all the special exceptions, recorded documents that we would be taking out of title insurance coverage, and so kind of putting their cards on the table about what the issues might be that you wouldn't be covered for, and then you've got some period of time under the purchase and sale agreement to obtain copies of those documents, review them, figure out is there anything here that's going to materially harm my use and enjoyment of the property, and then usually there's some mechanism in the purchase and sale agreement then where the prospective buyer can provide notice to the seller, well, here are my beefs with the title, 1, 2, 3, and then either they can be remedied within a certain time or potentially the buyer can have the option of backing out. So then I think Art spoke some about the recording system and how that works. So I'll try, you can see on page 9 there's some discussion about that. I don't know if he mentioned the concept of race notice, so I'll just refer to that here. That comes from the statute RCW 6508070. So you can see the scenario on page 9. Assume person A sells property to person B, conveys it by deed. Person B does not record the deed. Then person A sells the same property to person C, who pays value for the property and gets a deed. Then person C records. And so in that scenario, as long as person C didn't have notice of the prior conveyance to B, then C is going to be deemed the legal owner of the property, and that's because, again, they paid value, they recorded first, and they lacked notice of the prior conveyance to person B. So, again, the public record is really going to dictate in a lot of ways who has what property rights because we really reward people in most situations who get to the auditor's office first and record. And you can see the example there on page 9 of, this was an Idaho case, but it's applicable here to Washington as well, because Idaho, like Washington, has the race notice statute where, these folks had a real estate installment contract, the bank was holding the deed in escrow, and then they paid off the real estate contract over a period of 20 years. I think they were paying $100 a month or something like that, just faithfully making the payments, and they thought they had an easement for this private road to the property, and the deed said that there was an easement. These folks got the deed in the mail, sometime about 20 years ago, but again, they didn't know you have to record a deed in a race notice legal jurisdiction, so they just kept the deed, and then they go later on to the estate planner about 15, 20 years later, and they're saying, well, we own this property located here, and they pull the title records, and it still shows that somebody, the earlier owner, owns it. And so they're saying, well, why does the record show me that the Andersons own this when you're saying that you own this? And then they realized, oh my gosh, we have to go record. And then they ended up in a really kind of time-consuming dispute with the neighbor that escalated to litigation that we were able to settle, I think, literally 2 days before trial, where there were expressed easement theories, because we were making the argument that the owner of the property, if he had inspected it, he would have known that they were using this road, and we were arguing implied easement theories and prescriptive easement theories, and all of that took a lot of time and money, because we had to use sort of the spaghetti at the wall approach that Art was talking about. So they ended up, they kept the road, they were able to use the road, but if they had just gone and recorded that deed and put it into the public record, then they would have saved tens of thousands of dollars and a lot of heartache. So then taking that back to the title insurance context, again, the special exceptions are going to include those documents that have been filed for public record in the county where the property is, that would provide constructive notice, i.e. legally assumed knowledge, to later purchasers of the property. So then to sum up, in the preliminary title commitments, the title insurers will usually disclaim liability under the title policy for any matters arising from those recorded special exceptions documents. And again, that's just something that folks seem not to be aware of all the time, but that they should know. I'll just make a point here too. I think in the earlier presentation I was discussing road agreements and how if somebody's buying a property that's on a private road, you really want to see a road agreement in place beforehand, and so that's another issue that can come up in the special exceptions that should be disclosed in the preliminary title commitment, because if there's a private road but there's no road agreement in place, then you're looking at trying to get neighbors on board for road maintenance when they might not be. So then I've seen just a number of situations where you've got one or two people that are basically paying for everyone else to have a plowed road just because they know that if we don't do it, no one else will do it. And so that's something where, even though the road agreement is going to be not covered by title coverage, so any issues arising from that won't be subject to insurance, it's something that you want to see. And that when you get the preliminary title commitment, you can look for that. You can look for if there's a shared well agreement, shared septic agreement, because if you know you're getting into a property where you're not on municipal road, water, septic, you want to see something that's been put into the public record by previous owners of either your property and the surrounding properties that's providing for the maintenance and the use of those things, or else you could get in a really tough situation because then maybe the neighbor with the well or the drain field on their property is going to try to just take their ball and go home if they don't get everything they want, and it can be just a really tough situation. So that type of thing is a scenario where you want to see something in the title commitment. Usually you want to see as few documents and special exceptions as possible, but in certain situations there are documents that you want to be looking for if you're looking for access, water, other services that are often provided by local governments, where you're outside of local government jurisdiction. So that's sort of how the title policy is going to work, and what it's going to cover, what it's generally not going to cover. Again, knowing that standard exceptions can be oftentimes removed so that things like the water rights, again, can be covered. And then the special exceptions, usually you can't remove those because those are just parcel by parcel specific. So, sometimes people get in a situation where I want this lien removed. A lot of times those are just paid off at closing. And sometimes for other items that come up in the special exceptions, sometimes those can be cleared at closing. If it's a deed of trust, that often, usually goes away at closing. Sometimes they can't, and so that often affords the buyer the choice of whether they want to move forward with the deal or not. But sort of in a nutshell, that's kind of what we're looking at with what the coverage is, what the coverage isn't, and how that can apply to boundaries and easements and just general property dispute situations. So then I mentioned before, people get a preliminary title commitment. They rely on that document. They know that the title company has resources. It's usually called the title plant, where they're able to do research on a certain parcel and get all the documents that have been recorded affecting that parcel going back decades. And so they think usually that this is an authoritative statement about the title record for a given parcel. But the reality is that it's not. And it's not even intended to be that. People use it as such, but what a preliminary title commitment before closing, all it is just a statement by the title insurance company that this is what we commit to cover and this is what we won't cover. It's not meant to be an educational tool to teach someone about what the title includes and what it doesn't. So those differing understandings have led to litigation in Washington as well as in Idaho, and you can see some of the case law there on page 11, where somebody buys a parcel and the preliminary title commitment failed to disclose some huge title risk. In the Barstad case, it was apparently a senior lien that existed on two of the lots that were being purchased, and so there was a class action suit there. In Idaho, there was a case where the title company messed up the legal description of the property, and then it turned out somebody went down to the county treasurer's office to pay property taxes, and they were told, well, turns out you don't actually own this. And so that led to just extraordinary litigation and potential negligence claims against title companies. But what the Washington courts, as well as the Idaho courts, have said is that there's no basis for a negligence suit or like a malpractice suit against the title companies based upon what they disclose or fail to disclose in the preliminary title commitment. Rather, the liability is under only the policy itself. So, in other words, you have two different theories of liability. You can think about, on one hand, the tort theory of liability, where you've got the negligence, the malpractice, the torts that go to litigation. And then on the other hand, you've got the contractual basis for liability. And so the question with the contractual basis for liability is, does the policy cover the risk? And so it's just the same analysis that we've been talking about before, where even if the title company leaves something off of special exceptions, it still has to be a covered risk. And if it's not a covered risk under the language of that section of the policy, then even though somebody bought a property not knowing about this because it hadn't been listed, they might still be completely out of luck. And maybe that seems inequitable, but that's where the law is, because the law has made that distinction between the tort theories of liability and the contract theories of liability. Now, as a practical matter, I think a lot of times if the title company misses something on the special exceptions section of the policy, they'll end up being on the hook for coverage because a lot of the time the reason something was in special exceptions in the first place is because otherwise it would be under the covered risks. The exceptions, as I mentioned, are often just carve-outs from what would otherwise be covered risks. And so if the title insurer leaves that off, they could be liable for covering damages that arise from that, because they failed to put that into the exceptions. So the only recourse is going to be to seek coverage under the policy, and if you can't, then again, you're not going to get your defense paid for in court, and you're not going to be entitled to any actual losses to be compensated by the title insurer. So there's a difference there, and I want to make the distinction here between the preliminary title commitment and the abstract of title. So abstracts of title. There are people who are in business as title abstractors, and you can see the definition of what that is toward the bottom of page 11 of the written materials. But basically, the title abstractor is someone who makes it his or her business to dig into the history of a property and to find all the deeds, all the historical mortgages and liens, whether they've been cleared or not cleared, and to produce for somebody a report about the title history of the property going back to a certain date. And so that's the agreement as to what historical period the abstract will cover. That's often called the abstract certificate. So if I'm an abstractor, I'll give somebody a certificate that this report contains all the documents for this property that would create constructive notice going back to 1952. And then if the abstractor misses something in that report, then unlike the title company, they could be subject to damages for negligence as well as for contract damages. And so you can see that in the Bremerton case from 1912, that opens the door for both potential negligence damages and contract-based damages. So,
does that mean that somebody's being hired to perform chain of title, or is a chain of title the same thing?
I would think of an abstract as chain of title plus. So you get the deeds, because the chain of title is usually restricted to just the deeds of conveyance, but the abstract will also go beyond that and find any mortgages that were recorded, because usually if a mortgage has been put on a property but then paid off, that won't show up in the preliminary title commitment that someone gets today because it just doesn't apply to the property anymore. But the abstract could go in and find that mortgage from 1968 that got paid off and produce that as part of the overall history of the title. And so, there are people who are in business for that, and there's law governing it. I don't interact with that, very frequently, and so sometimes people ask me, well, what would be the purpose in getting the abstract of title as opposed to just the preliminary report? Well, for one thing is that there could be issues in the chain of title that could, really threaten someone's ownership of the property, and even if that's something that would be covered by title insurance, which ordinarily it would, it's still just not something that you want to experience, especially if you're talking about a particular parcel that maybe you've been eyeballing for years and you've had all these plans of what you're going to do with it when you buy. Maybe you just want to be as certain as you can that there aren't going to be issues after you close. So an abstract of title can provide potentially more psychological security on that point. Another reason, kind of going the other way, that somebody might want the abstract of title is if they're trying to back out of a deal. Because, as we know, when somebody signs a real estate purchase and sale agreement, they're contracted to close unless one of the contingencies is triggered. And, frankly, a lot of the business that I've had seemingly in recent months has been some variation of people who signed a purchase and sale contract and they're trying to find a way out of it for one reason or another. Sometimes it's the seller because they contract for a certain price and then they go see the Zillow estimate and their eyes pop out of their head because they're thinking, well, how is this $80,000 more? I was defrauded. What can I do? And frankly, probably not much, right? But if somebody's trying to get out of a deal, well, the law says the seller has to be able to convey marketable title, or else there's no obligation then of the buyer to close. So what's marketable title? Well, the definition there from case laws on page 12, the Hebb versus Severson case, kind of one of the seminal cases in Washington on purchase and sale agreements. And so, marketable title, one that is free from reasonable doubt and such as reasonably well-informed and intelligent purchasers exercising ordinary business caution would be willing to accept. So, all that means basically whatever the court says it is. And but the important thing to note is that even if the title company is willing to insure title, doesn't necessarily mean that the buyer's got marketable title. So you can have potentially a title policy with really high premium covering potential issues, but it still doesn't necessarily mean that the seller has succeeded at conveying marketable title such that the buyer's obligation to close still persists. And so I think sometimes if somebody is trying to find a way to get out, from the buyer's standpoint, finding an abstract of title might enable somebody to find that, that lien or that other document that creates reasonable doubt, such that if in the exercise of ordinary business caution they wouldn't buy the property, and then potentially use that as their way out. So a buyer, in short, may wish to get an abstract to be sure that the seller can convey marketable title, and also to have greater recourse in the event that the abstractor fails to disclose something in his or her report, whereas there really is no recourse, at least from a tort standpoint, against the title insurance company. All right, so I don't know how I'm doing on time here. Let's see. Okay, got about 7 minutes. So when does legal due diligence matter? Well, it's easy to say any scenario. I would never tell somebody not to review the public record documents on a piece of property before they buy. Whether we're talking about property in the city, out of the city, on planet Neptune, wherever. I mean, every property is potentially subject to title-related risks, as well as risks related to just the use of the property, water issues, building and zoning issues, Hearst-related issues, that we've all been dealing with. So, so I would say, in general, any property. But in my experience, as I mentioned earlier, when you're talking about the rural parcels outside of the platted subdivision, that's where these issues can really come up. Developers creating subdivisions are usually going to clear any title issues with the land before they spend a bunch of money on it and start parceling it out into lots. So, quite frankly, it would be pretty surprising to come across a platted subdivision lot where there was some old title issue that hadn't already been cleared. But the same doesn't apply to the rural parcels. It's entirely possible that you can see questions about who has ownership when there's not been a developer involved to research those issues and take care of it before they start marketing the properties. Although, of course, as written there, once the plat is recorded and then you start having one person convey a lot to the next, these issues can certainly come up. And then again, just with the road, water, and septic, that's really the big three of stuff that I deal with. And again, those issues are going to come up with the rural properties much more so than with the subdivision properties, especially not properties that are in the city. And the same goes for easements and shared well agreements and frankly boundary issues as well, because it's just the simpler a legal description is. If there's a surveyor who can whack me on this because I'm wrong, please do so. But it seems like the simpler the legal description is, maybe the less chance there is of people not knowing where the boundary is. If you've got a lot that's 120 on north-south and then 400 on east-west, and it's pretty clear how that looks, it just seems less likely that you're going to have potential boundary issues than where you've got the legal descriptions that go on for 3 pages plus. So really, a lot of the people that I work with are those who are out there in the country and have some of those lengthier property descriptions and those problems that come up. So, the rest of that is on page 13. So that's pretty much the remainder of the items there. And so I think I have a few minutes left if there were any questions that didn't get asked. Yes, sir.
On your last page, it says in the first world. What does that mean?
That refers to the Hearst decision from a couple of years ago regarding water rights from the Washington Supreme Court that said that if you're going to get a building permit for parcels, affect a lot of rural parcels, that you have to show water is legally available. In other words, that you're not going to be impacting minimum in-stream flows. And so it has really, in short, led to a lot of questions for owners of rural property about when and how they can get building permits and and have water availability for that, and caused, created a lot of work for lawyers and for.
Is that applicable like Arizona and California?
No, this is a Washington State Supreme Court decision, so it was. So this is not a U.S. Supreme Court decision that would be potentially affecting other states. And the legislature has, responded to some extent to mitigate some of the issues, but we're certainly still, working with that. And so that, that really argues for, doing that due diligence on these issues for those rural parcels that are going to need a well. Because now you've got to deal with, is water not just physically available? You can have water in the ground, but then there have been questions in the last couple of years about legal availability, and that goes to what's the in-stream flow minimum and all that stuff that we get to deal with the agencies. So, were there any other questions? Well, then I'll stick around for a few minutes. I think Art is coming back up here next to finish us out. So, thank you.